Please be seated. Good morning. We're here for oral argument in case number CV24-0057, PIMA County versus City of Tucson. Council, we're recording and live streaming the argument, so please identify yourselves and your client at the beginning of your argument. Each side will have 20 minutes. But you're not obligated to use all that time. Appellant's counsel, you're responsible to watch the clock and reserve as much time as you'd like for rebuttal. Also, keep in mind we've read the briefs, we've studied the record, and we've discussed the case in conference. So, counsel for appellant, you may proceed.
Thank you. May it please the court. Colin Naylor for plaintiff appellant, Pima County. Here with me today is my colleague Ian Joyce. Organizationally, I was planning to first address the form of judgment issue, and as a sneak preview, I'd probably focus most of my time there. As time permits, I'll briefly address the attorney's fees issue at the end, and I'm going to watch the clock but try to save about 5 minutes for rebuttal. On the form of judgment issue, I think we need to recognize that the starting point here is that there's absolutely no dispute at this point that the city's differential water rates were null and void the moment the city council enacted them in their entirety. By statute, ARS 951101, the city was required to do a cost study before enacting those increased rates. It didn't do that timely study, and that's why the trial court found that the rates were invalid, and the city has dropped its cross appeal of that issue. So that issue is resolved. But despite the increased rates being null and void in their entirety...
Has the city repealed the ordinance since Judge Warner's ruling?
No, Your Honor. To my knowledge, they have not. And I've checked the city site to see if there was any sort of repeal. Did not see anything like that. What happened is that after the trial court judge entered its summary judgment ruling saying that the differential rates were invalid because they didn't comply with statute, the city council basically said it was going to stop, at least at that point, enforcing the rates going forward, but said nothing about repealing the ordinance or refunding or crediting the millions of dollars it had collected under those differential rates. So we have the summary judgment ruling that the rates are null and void in their entirety. But it's also true that the final judgment by the trial court is much more limited than that, both in terms of the declaratory relief that was granted as well as the injunction. And the reason the trial court did that was simply a pure legal error. What's clear from the trial court's order is that the judge believed that he was constrained from entering a broader declaration or injunction based on standing principles. That's the reasoning the trial court judge gave, and that's the argument the city made. Now, the city never actually cited any authority to support that theory, and neither did the trial court. And it's just, as a matter of law, that's just incorrect. And we've cited a number of cases that stand for the general proposition that in deciding the proper form of relief, the issue the court needs to look at is the nature and the scope of the violation that's been established, not the particular plaintiffs who happen to be in the case. Just to highlight a couple cases that talk about that issue for the court, one comes from the Arizona Supreme Court. That's the Fan v. State case, which dealt with a statutory scheme enacted by ballot initiative. And there, the Arizona Supreme Court was very clear that if that statutory scheme violated the Arizona Constitution, then the trial court had an obligation to declare it invalid in its entirety and enter similar injunctive relief. And that's exactly what happened when that case went down on remand. The statutory scheme was struck down because it violated the Arizona Constitution, and the Arizona Department of Revenue subsequently did the right thing. They provided credits to all the monies that had been paid under that unlawful statutory scheme. We've also cited actually several federal cases that talk about this issue.
You've argued that the injunction should have ordered a refund to all Tucson water customers. But the complaint never requested any type of refund, restitution, disgorgement. It didn't request any monetary relief, did it?
It didn't request monetary relief, Judge, and that's part of our reason why we've explained that the notice of claim statute just had no application to this matter. What we sought was declaratory relief and an injunction against an ordinance that was still in effect that continued to accumulate these fees on an ongoing basis. As part of that, once we had the summary judgment ruling, we basically requested that the ordinance be unwound, a form of a mandatory injunction that not only the ordinance be not enforced on a going forward basis, but that the city return or credit the monies it had collected under that ordinance.
You requested that in what manner?
So, Judge, I believe it was intertwined with the declaratory and injunctive relief we sought. We were never asking for, X amount of damages.
Is it accurate that the first time any mention of a refund came up is when your client lodged the proposed form of judgment?
Your Honor, I can't say offhand whether that was the first time the issue of a refund was raised. Kind of going back to the history, it gets a little convoluted because in the midstream of the litigation, the city created this exemption for government customers, including PIMA. Basically, in our view, they were trying to moot the case, and the trial court rejected that as the theory that had rendered the case moot. But as I recall, that's kind of the first point where the issue of a refund or a credit came up. One thing I would note, though, about the proposed form of judgment is that the city never objected that piece of it there was anything improper about it. And there was really three pieces of the proposed declaratory and injunctive relief we were seeking. One, the declaration that the ordinance was invalid in its entirety. Two, the injunction against the ongoing enforcement. And then three, the last piece, which is the one that they really seem to be focused on, which is basically unwinding the consequences of that unlawful act.
But was there a claim in the complaint, or was there a motion filed seeking to unwind the consequences of the ordinance? Or was that raised for the first time when you lodged a proposed form of judgment?
So, I'm thinking back to the complaint, and in our prayer for relief, we had a number of requests. I don't have that document handy with me, but there was the declaration, there was the injunction, as well as kind of the catch-all request for any relief that the court deems just and proper, which in our view would encompass the unwinding of the ordinance, because it's just intertwined with the other relief we're seeking. And it's not
monetary relief and injunctive relief are two different things. How are they? How does obtaining injunctive relief entitle you to monetary relief with no separate request?
Well, I would first answer that it's part of the injunction we were seeking. Not only kind of the forward-looking enforcement of the ordinance, but also it's clear at this point that the city was collecting monies that it had no legal obligation to collect or keep. And I think there's several reasons why it's not a claim for damages, as you would normally construe such a claim. The fact that this was an ongoing ordinance, the fees were piling up each day. And so it wasn't a case where we were asking, give us X amount of damages. It was really, stop the fees, give us what you unlawfully collected. And there was different ways. The city had all discretion in how it could do that. It could have provided a refund, or it could have done a credit, which is what it ended up doing, similar to the Arizona Department of Revenue in the FAN state. And so the city would have had similar discretion as to the other customers that it unlawfully collected millions of dollars from. On the federal authority, I wanted to highlight just a couple points from the City of Chicago v. Sessions case from the Northern District of Illinois, because I think it's a really helpful case in multiple respects. First of all, it's factually very analogous in terms of the types of arguments that were raised. There, the city of Chicago challenged some conditions that the federal government, the U.S. Attorney General, had imposed on federal grants that had to relate to criminal justice funding at the local level. And those conditions were determined to be unconstitutional. So in response to that, the federal government argued that the scope of the relief needed to be constrained to the geographic boundaries of the city of Chicago for the very same argument that was raised here, because of standing principles. And the court roundly rejected that argument, said that it's the nature and scope of the constitutional violation that defines the remedy, not the particular plaintiff. Cited a number of cases for that proposition. And it made a couple other points that I think are key here. First, almost by definition, an injunction is not overbroad where it simply prevents a government official or an entity from acting beyond its statutory authority. The exact same issue we have here. Second point the court talked about is just the judicial economy concerns. That that policy concern strongly counsels against requiring every single person who's impacted by an unlawful act from bringing their own separate lawsuit. And the third point the Northern District of Illinois made is that if you do what the trial court did here, is that you limit the declaratory relief as well as the injunction just to the named plaintiff or plaintiffs, you're effectively inviting the government to continue enforcing the unlawful action against other parties who just do not happen to be named in the case. And that's contrary to the rule of law and, quote, the role of the courts to ensure that the law is enforced, end quote. That's from page 4 of the Sessions opinion. And so all those rationales apply just as strongly to this case. On the attorney's fees, as I mentioned before, I'm not going to spend too much time on it. I'll just quickly raise a couple points. First, we recognize that the trial court does have discretion when it comes to fee awards.
Perhaps a lot of discretion?
It's a good amount of discretion, but I would...
Would you characterize it as broad?
I would agree that it's broad discretion, Judge. But I think that broad discretion does end when you talk about a pure mathematical error or just a simple failure to follow the China doll standards.
Okay, and what's the mathematical error?
So the mathematical error is that what the trial court judge said is he went through a couple different steps to cut down the fee award. The first one he said is that I'm going to make an off-the-top 15% reduction because you had some claims and theories that didn't succeed in the case. Then he said, I'm going to take another 40% to account for you overworking the case. The problem is that if you're going to do it that way, you need to take off the 15% first and then apply the 40% to the remaining 85% that's left over. Otherwise, you're applying 40% discount to an amount that's already been taken off completely. So it's a double counting issue.
And what would you say is the remedy for that, what you describe as a math error? Is it for us to redo the calculation or to remand to let the trial court redetermine the award?
I think the remand is the appropriate remedy, Judge, both to correct that error as well as give the trial court instructions to follow China doll. And the main
why is a remand necessary to correct a math error?
Well, I suppose this court could do it either way, just correct the math error itself. It seems to us, at least, that the remand is appropriate because that would allow the trial court to address both issues at once, the legal error as well as the math issue. On the China doll, the one issue I wanted to talk about just briefly is the overworking issue. And the problem there is, this is even a little bit different from China doll in that we're not talking about claims or theories where the county failed to succeed. We're really talking about claims, theories that were never addressed by the trial court because we won on our first argument as to why the ordinance was unlawful.
Well, there was also litigation about the equal protection issue, which the county was not successful on.
Correct. And that was part of the 15% cut that the trial court made. So here I'm talking about the 40% where the trial court said that, in my view, the case was overworked because the issues here were more legal than factual. So he didn't feel like a bunch of discovery was necessary. The problem with that is that, and the trial court conceded in his summary judgment ruling that he was not even going to look at the other arguments, the alternative arguments we had raised as to why the ordinance was unlawful, because he found for us on the first issue, which had to do with the timing of the cost study, which I would agree was a more legal issue. But the alternate theories that were never addressed by the trial court, that was not the case at all. Those issues had to do with things like whether the water cost study was a valid study, which, as you can imagine, is a very technical, fact-intensive issue. Other arguments that were raised had to deal with our challenges to some of the policy justifications the city had raised for the ordinance, like the idea that the ordinance was going to promote annexation into the city or incorporation. And so that, too, required a lot of factual investigation, discovery, deposing the number of witnesses that had been disclosed by the city as potential trial witnesses.
Mr. Ayler, I know you were trying to reserve a few minutes for rebuttal, but quick question on,
Yes.
I think the county asked for attorney's fees on appeal under 12-348-01. If the county's successful on appeal, are we obligated to award the county attorney's fees on appeal?
Yes, that is a mandate.
Then the same question, if the city's successful on appeal, are we obligated to award the city their attorney's fees?
For the appeal, I believe that's correct. It is a mandatory statute. It's not like the contract-based claims statute.
What if there's partial, what if, split the baby, what if there's partial success by each side? Then what?
Well, that kind of raises a different question of who's the prevailing party. We never had to deal with that below because it was...
The statute says successful party, correct?
Correct. I believe that's right, the language it uses.
Okay.
I'll use reserve the rest of my time for rebuttal. Thank you.
Thank you.
Good morning, and may it please the court. My name is Charles Workin. I represent the Appalachee City of Tucson. This case at this stage is really primarily about the issue of a refund of differential rates paid by residents of PIMA County who were customers of Tucson Water.
Mr. Working, let me ask you just a quick question on this. The city has never objected, either below or here on appeal, never raised the issue of the refund that the court ordered to the county. Is that correct?
That is correct. We didn't object to the form of judgment that was proposed as to making a refund to the county. And I will say at this point, instead of later on, that the notice of claim statute doesn't apply to the county. The notice of claim statute requires persons to submit a claim if they're seeking monetary relief from a governmental entity, and person as defined in ARS 1-215 does not include a governmental subdivision.
Before we get to the refund issue,
yes, sir.
What about the scope of the injunction? The county submitted a proposed form of judgment that enjoined enforcement of the differential water rates for customers. The city objected, and the court sustained the objection and limited it to the county. It enjoined it as to the county. So yes, the judgment says that this ordinance is invalid and void, but only as to the county, and you can go ahead and enforce this void ordinance as to all others. Is that what the judgment says, and how does that make sense?
But the city has not done that.
Okay, but it could. That's where the judgment leaves it.
You might read it that way, but the city, although I understand it has not repealed the ordinance, instead it has reinstituted the process to do a study and adopt a differential rate that would withstand scrutiny. In the meantime, the city stopped collecting any differential rates from customers other than Pima County.
But just in a larger sense, if an ordinance is invalid and
Yes.
void because it's adopted in violation of state
Yes.
law, it's void for all purposes and all parties, or all individuals, persons, not just the plaintiff in this case.
It is, Your Honor. But then that points out a unique aspect of this case, and that is that no one else who is obligated to submit a notice of claim did so, and that the county did not have standing to represent the interests of those resident customers. That issue was decided. It is not contested on appeal. So they have no standing to seek relief on behalf, monetary relief, or any relief for that matter, on behalf of the resident customers. So it's a unique situation, and it makes it unlike the Fan case. It makes it unlike the Chicago case that has been cited, because none of those cases deal with a monetary claim. And what we have here, although, as you noted, the complaint did not seek any monetary relief. The monetary relief was an afterthought. It came up when the form of judgment was proposed. And the city didn't have any problem with making a refund to the county, although it had not been prayed for in the complaint. That was just let's say an executive decision that was made. But we did object to the form of judgment, not alone on standing, as I think my friend said, but also because the notice of claim statute had not been complied with.
Mr. Ehler makes the argument that monetary relief in the form of a refund is incorporated within a claim for injunctive relief. What's your response?
No, it isn't inherently incorporated. You can have claims that purely seek declaratory relief or injunctive relief, and one of his examples in the reply brief of a case to which the notice of claim statute does not apply is when one sues to abate a nuisance. But if, on the other hand, you're seeking a declaration or an injunction that is a predicate to getting monetary relief, then it's not inherent. You've got to comply with the notice of claim statute if it applies to you as a plaintiff. Again, it doesn't apply to the county, but it does apply to the resident customers in Pima County. So, and those customers, could have joined in the lawsuit. They could have made their own claims. In fact, when you study the detail of the fee application, the itemization of fees requested by the county, you see that after the equal protection claims were dismissed, the county was considering bringing in a resident customer, or many of them, as plaintiffs, and never did so. But if those folks were to be entitled, in order to be entitled to monetary relief, they need to make a claim pursuant to the notice of claim statute. It may not be too late for some of them, although some time has passed, and they could assert the judgment that invalidates the ordinance, and that would preclude that issue in their case as to the county. But none of them have done that either. So, the one last thing on the notice of claim issue. The reply brief argues that it couldn't have been complied with because the resident could not state a specific amount for which the claim can be settled, which is a necessary component of a notice of claim. That's not the case. At the time of making the notice of claim, of giving notice of a claim, a resident could say, I have paid X dollars up to this date. And I will settle for, they could say any amount. And also under the Graber case, Graber versus City of Phoenix, if the claim is based on facts that are not changing and the claim is accruing, the later accrued damages are covered by that notice of claim. So counsel is simply incorrect in saying that the statute could not have been complied with and therefore it does not apply. I'll turn to the issue of attorney's fees briefly, as to which, of course, Judge Warner has very broad discretion. And I'll first note, though, that this argument that there was a double counting or a double deduction and a math error, that's a new argument on appeal. That was not an argument made to Judge Warner. Nevertheless, it's clear that what Judge Warner intended to do is to reduce the fees, the amount requested, by 55%, and not to do it in increments of 15 and 40% or 40 and 15% sequentially. And
Well, why not? Those were the numbers Judge Warner picked. He didn't say 55%. He said, I'll disallow 40% for overwork, and I'll disallow 15% for the other.
this is where I wish we were in the classroom and I had a blackboard. Because bear with me for a moment. The fees that were requested were some $648,000. By the way, not $642,000 in the initial application. Although in the reply to the response to the motion for fees, the county reduced its claim to $642 because of an objection that I made, one of the many objections I made. But the court was working off of the original amount of $648,000. If you take 45% of that, the number that you get is $291,791.
240%.
If you take 45%.
So a 55% reduction is what
No,
you're saying.
if
That's how you're getting
did I-
55%. You're doing
he had
40.
15 and 40 were the two numbers he was using for unsuccessful claims and overworking. That's a total of 55%. Okay, so that means that the net fees he wanted to award were 45% of the amount requested. And so my math on the blackboard here is 45% of the original amount requested. Original amount, $648,424. 45% of that is $291,791. His minute entry and judgment interposed a couple of numbers and wrote, and he awarded $291,179. So instead of 791, it's 179. It's clear from that he did not intend to do a two-stage calculation, taking 15% and reducing the amount to whatever that is, 85% of the total requested, and then applying 40% to that to get a net number. He intended 55% as a deduction total as applied to the total amount requested. That's,
The 15% covers unsuccessful claims.
yes,
Presumably, the overwork occurred on the unsuccessful claims as well as the successful claim, right? Presumably, there's overlap between the 40% over excessive work and the 15% unsuccessful claims, right? I mean,
perhaps, but we don't know what was in Judge Warner's mind and how he viewed that. He did, I'll give it to you that that's as possible as the alternative. But what is clear to me from his math is that he did not intend a two-stage deduction, and he arrived at the number that he intended by taking 55% off the top.
well, maybe he didn't consider the possibility that taking 15% and applying it to the full amount, even the 40% that had already been disallowed, was double counting. Perhaps he just hadn't considered that.
but it doesn't, there isn't a double deduction or a double count, I think is the phrase they use, if you just follow his math. There's no disadvantage. Well, the county argues that it's been disadvantaged, but the math doesn't prove that out. It only works that way if you assume that he intended to do 2 stages, and the mathematics do not support that conclusion. So,
Would it make sense for us to remand so Judge Warner can clarify what his intent was?
you could do that, but I think his intent is clear from the math. So I think it's unnecessary. And given his broad discretion, I think you have to defer to the not just the likelihood, but I think the inescapable conclusion that he intended to take 55% off the top.
What about, Counsel, what about the overworking the case?
Yes.
I'm interested to know a little bit more of your thoughts on that. Why was it not defensible in your mind for the county to pursue numerous depositions, engage in discovery, of course, and then have the city come back and say, guess what? Your claim was so stinky, or you should have filed a motion for summary judgment, 2 months into the litigation. You could have gotten rid of all these fees.
And indeed, they could have and should have. The primary claim here is the statutory violation claim, that there wasn't a proper cost of service study done. The facts surrounding that were known before the complaint was filed. And there wasn't any need to take depositions, not even one, to establish the facts that support the argument that the statute was not complied with.
Is there anything in the record to indicate that any party ever proposed to the other party that we stay fact discovery until the legal issue is resolved?
I don't think there is, Your Honor. No.
So how is it fair to hold the county responsible for all those fees? Maybe fair is not the right word.
Well,
is it legally defensible? I mean, what was the city's main position right from the get-go?
It was that the cost of service study doesn't have to be done before the ordinance is adopted. Well, let me back up in history.
Seems odd.
Okay, they adopted an ordinance with differential rates, and then they directed the experts to do a study. And the experts did the study, and then they adopted a new ordinance that had the same rates. But they felt that at that point, the second ordinance was supported by the study. And, our argument below, and had we persisted with the cross appeal, we would have been arguing that there's an issue about, under the statute, a legal issue, whether this cost of service study has to precede or may follow the adoption of the rates. And then also there's a question of fact as to whether that study shows that the rates are reasonable. The city decided not to pursue that. But that was the city's position, that it could support the rates with a after-the-fact study, before the rates went into effect, by the way. Okay? But as to the overworking, it's not just a matter of the county sticking with its or prioritizing its statutory violation claim and swinging for the fences on that one early on in the case, but it's that, as I argued in opposition to the motion for fees, and as Judge Warner apparently agreed, the case was overworked. He didn't question the rates that were applied, that were charged. He didn't question the 9 lawyers that worked on the case, but he did conclude, as someone with applying his own experience as a lawyer and a judge, that there was simply too much work done on this case. And I'll note before I run out of time that these claims, these 5 claims that were made, were each different. They had different elements. They could have been pursued separately. It's not, although they sought a common objective and there was some commonality of facts among those 5 claims, there are distinctions among them. And, the statutory violation has different elements than the discrimination claim and certainly the special law claim and different elements than the equal protection claims. So, the court thought that the pursuit of those, the work on those, and perhaps as well the work on the, not just perhaps, certainly the work on the statutory violation claim was just too much. It was more than required. And I think, again, and think is an understatement. You must give deference to the trial court's discretion. He presided over this for a long period of time and knows it better than perhaps any of us ever will. I would welcome any further questions. Or I'll heed your admonition that I don't have to use all my time.
So just a few brief points. First of all, I wanted to follow up on the questions that were asked about the relief we requested in our complaint. And we went ahead and pulled that up. So this is IR1 at pages 30 and 31. In addition to the various declaratory relief, we asked for an injunction prohibiting Tucson from enforcing ordinance number 11881, enter other injunctive relief that is necessary and appropriate to ensure compliance with the foregoing constitutional, statutory, and contractual provisions, as well as such other and further relief that the court may deem proper under the circumstances. Now, the city's council talked a lot.
And so your point is that monetary relief was included within that?
I think the latter 2 requests do cover the type of monetary, related relief we were asking for. So the city's council talked a lot about the notice of claim statute. And I think it's worth reemphasizing that they're only talking about one piece of the 3 components of the judgment we were asking for in terms of the declaration and the injunction. And on that 3rd piece, one thing I would note is it's quite common that a case can fundamentally be a case about declaratory and injunctive relief, which is the case here, but still have some monetary components kind of mixed in the case. A good example of that is a case that the city cites relating to the notice of claim requirement, the UMB Bank case. And that case was about the plaintiff seeking to get a receiver appointed. The reason for doing that was clear. They wanted to collect debts that were owed by a charter school, and so that's why they were trying to get a receivership. But the court made clear that that by itself doesn't fundamentally change the nature of the action. A couple quick points on the fees. I didn't quite understand the city's argument that we didn't raise the math error below. I suppose we, in our discretion, we could have filed a motion for reconsideration below on that issue, but it's certainly not mandatory. The city kind of, its description of count 1 was also a little bit incomplete. It wasn't only about the timing of the cost study. What that statute requires is just and reasonable rates if you're going to increase water rates by a municipality. And so in addition to the timing issue, we had all sorts of arguments of why the rates were not just and reasonable, including that the cost study was invalid and that the various policy justifications were arbitrary. And under China Doll, we submit that that's what a reasonable and prudent lawyer would have done, not put all your eggs in one basket, but argue against the ordinance on alternative theories. My time's up. Thank you.
Counselor, thank you both for your arguments this morning. We'll take this matter under advisement and issue our decision in due course. The court stands in recess to set up for the next argument. Thank you.
Thank you.